Hello, all, this is Chartered Accountant Omkar Gadge. So, friends, we are having this GST series, and today is the second session of the series. We are going to discuss the provisions of Section 112 in a Q&A form. So, who can file the appeal and when the appeal can be filed before the GST? The first question we are going to discuss is from the perspective of the taxpayer. Any person who is aggrieved by the order of the first appellate authority or the revisionary authority, or as we had also discussed about the anti-profiteering authority, can file an appeal within a period of 3 months from the date on which the order sought to be appealed against is communicated. Now, yeah, please remember here that section 169 particularly covers as to what do you mean by communication of a notice, an order, etc. under this law, and therefore this specifically mentions within 3 months from the date on which the order sought to be appealed is communicated, and therefore that day it may be appearing on the portal, on email, or on any other way that has to be taken into consideration, unlike the earlier pre-GST regime scenarios where the date of receipt of orders was going to make a difference, or that would be considered as a pivotal date for determining the date of communication. Secondly, it also covers any other date as notified by the government. So currently, as we know that for the period 1st July 2017 to date, the GST Appellate Tribunal is yet to formally operate or come into the operation. And therefore, for those appeals, the order might have been passed by the appellate authorities or the revisionary authorities long back, and 3 months have already elapsed since then. So for such cases, there will be a date which will be notified by the government. The next is, can the GST refuse to admit an appeal? Now here we are not trying to say that whether the appeal is going to be accepted or rejected, whether the appeal would be admitted or not. Can the GST have the discretionary powers in this regard? The answer is yes. In case the appellate tribunal finds that the amount involved in the appeal in regards to the tax, interest, penalty, or any input tax credit amount, let's say, involved is less than rupees 50,000, at their discretion they may say that the appeal is something which can be not admitted at the GST. Next is, can the GST department also file an appeal with the GST? The answer is of course yes. If the if the GST department is is really of the opinion that after the order which has been passed by the appellate authority, or order which has been passed by the revisionary authority, or any other order under this law, where the commissioner is of the view that the order needs to be challenged, then he can file an appeal against such order passed by the first appellate authority or the revisionary authority, and the appeal has to be filed within a period of 6 months, from the date on which such order has been passed. Likewise, any other date will be notified by the government for those cases which are currently regarding the orders which we are having right now with us, because the tribunal is yet to come into effect. Secondly, we also would like to understand is that what happens, I mean, very importantly, the 3 months and 6 months period, if you see, for the taxpayer, the 3 months period starts from the date on which the order is communicated. For the department to file an appeal, the appeal has to be filed within 6 months from the date on which the order has been passed. So this is the prominent difference in two. Next, what happens to the application which are received from the department? The simple rule is that they will be dealt with mutatis mutandis as the taxpayer's appeal is dealt by the tribunal. So the tribunal is going to deal with the appeal filed by the department as if it is an appeal, as it is dealing with an appeal filed by the taxpayer. So there is no separate treatment whatsoever. Now, when is a cross objection required under the law? What the provisions say is that if on the receipt of an appeal which has been filed under this provisions of this section, the party against whom the appeal has been filed or preferred, notwithstanding that he may have not appealed against any such order or the part thereof, means if there is an appeal which has been preferred against me, let's say I am the taxpayer, and it may be against the whole of the order or the part of any order, I have a right to file my cross objection against this part of the order within a period of 45 days from the date on which this notice regarding, or I am in receipt of the notice regarding the appeal filed against me. So this time of 45 days is permitted for filing my cross objection against any of the part of the appeal which has been filed against my original order or my appellate order, as the case may be. The next is, Is there a condonation of delay possible? Now, of course, we have seen that in the current regime, the service tax or the excise or the customs appeal, the condonation of delay is something that has been done by the honorable tribunals at various scenarios, under various scenarios and under various cases. Of course, the circumstances matter a lot. Primarily, what the law say is that for any appeal filed by the taxpayer, the standard time period to apply is 3 months from the date of communication of order. The condonation of delay can be for another 3 months from the said date. From the date on which your original time period is expiring, another 3 months you can file the appeal under the condonation of delay scenario. For the department also to file the appeal, the actual time allowed is 6 months from the date of passing the order. They can also have another 3 months for filing their appeal. That is the extended period of 3 months. And in case of cross objection memorandum, as I said that an appeal was preferred against me as a taxpayer, I wanted to file my cross objection. If I could not file it within 45 days, another 45 days time period will be allowed to me as a part of condonation. Please remember that for the purpose of condonation of delay being accepted, if the tribunal is satisfied, if the registrar is satisfied that there was a sufficient delay for not being able to file or submit the appeal, only then the condonation of delay in the appeal would be admitted. Friends, as far as the technicalities of application and pre-deposit is concerned, we are purposely putting it up in the next video, since we do not want to mix up the part of the procedures with the legal requirements. So this was our provisions of section 112. I hope you find it insightful. We'll definitely meet in the next video. Thank you so much. Have a great day ahead. Jai Hind. Take care.